Reproductive rights as the dominant framework in this movement is over. It has to be over. Not to drag, as the kids say, the many brilliant people who have fought and toiled to maintain the abortion rights that we have, but those abortion rights don't mean anything to so many people. Black and brown people, to low income people, to trans and non binary people. And that's why the movement needs to be entirely consumed by the reproductive justice movement. Because RJ includes reproductive rights, but it also includes so much more. It's a movement that was created by women of color who saw that the dominant reproductive rights movement wasn't speaking to their needs. They saw that the right to terminate a pregnancy is important, but the right to have a child safely is equally important, and the right to parent and raise that child safely is equally important. And so that's what's so exciting about it, right? RJ demands big thinking, and it demands going beyond the legal right to an abortion. As a lawyer and a journalist, the reproductive justice framework has allowed me to look beyond the law and to place my work into a larger context. I can tell you that Roe allows abortion up to the point of fetal viability. I can tell you that Planned Parenthood versus Casey's undue burden test prohibits substantial obstacles being placed in the path of people seeking abortion. And while that's important, because knowing our legal rights is absolutely critical, it's also not enough. And that's where RJ comes in. A reproductive justice framework complements a reproductive rights framework by placing abortion in the broader context of human rights, because legal rights are not sufficient. Abortion law is not abortion justice. Robin West, who's a legal scholar and associate dean at the Georgetown Law School, has argued that what we have right now is not a legal right to an abortion, but a negative right against the criminalization of abortion in certain circumstances. And even though Roe grants a fundamental right to a pre-viability abortion, that right is still subject to state regulation, depending upon whether or not a court views a particular regulation as an undue burden or substantial obstacle to abortion under the case Planned Parenthood versus Casey. And since the court decided Casey in 1992, 91, 92, states have pressed their luck to determine how far they can go when it comes to imposing burdensome regulations on providers and on patients. They essentially want to test the court's resolve to see what the court will and will not allow states to do. And so they impose increasingly burdensome regulations on patients and patients and providers in order to make it difficult, and in some cases absolutely impossible, for pregnant people to access abortion. And now they've got a new trick that they're trying, these states. They're trying to recast outright pre-viability abortion bans as regulations. And so if they couch it as a regulation, that means they have to go through this whole test, but it's utterly ridiculous. There's a case that the court is going to consider eventually, because it's conferenced on it about 10 times, I think we found out today. It's a case that's challenging Mississippi's 15-week gestational ban. This is a law that bans abortion after 15 weeks. In that case, Mississippi is actually arguing that its pre-viability ban isn't really a ban, it's a regulation. It's a regulation on the time period during which a person can get an abortion. And yes, that is as bonkers as it sounds, because a regulation on the time period during which a person can get an abortion is a fucking ban. That's what it is. And here's the worst part. The Supreme Court ruling that we got in June Medical Services was good, to the extent that it permitted the few clinics left in Louisiana to remain open, but it was terrible insofar as Roberts' concurring opinion, Chief Justice John Roberts, he fired a warning shot at the future of abortion rights law. And, you know, we were all very nervous about June Medical Services, weren't we? I bet most of the people on this Zoom call were very, very nervous. I was practically in a blind panic. So when it came down that Roberts had actually sided with the liberals, I was elated. But then I read Roberts' opinion and realized that he had just teed up a fight about what the Planned Parenthood versus Casey undue burden standard means. Does Casey require balancing the burdens of a particular law against the benefits of that law, as the court said that they have to do in Whole Woman's Health versus Hellerstedt, which was that landmark case that abortion rights activists and lawyers won in 2016? Or does Casey permit courts to just simply make a judgment call as to whether a law is an undue burden? We're already seeing the effects of Roberts' concurrence. States all over the country are clamoring for a rule on this issue so that they can go wild with regulations, knowing that Trump judges sitting on courts around the country will never overturn a regulation on the grounds that it's an undue burden. The Eighth Circuit, for example, just recently permitted a series of abortion restrictions to go into place, including a D&E ban, saying that they didn't think that the D&E ban posed a substantial obstacle, even though it literally bans a particular kind of abortion, the most common kind of abortion, in the second trimester. But apparently that's not a substantial obstacle. And they made that judgment call, and they are arguing that Casey doesn't require them to weigh benefits and burdens, because if they weighed benefits and burdens, they would lose because so many people get D&E abortions. The Sixth Circuit is allowing Kentucky to go forward with what is essentially an admitting privileges law, very similar to the one that we saw in June Medical Services versus Russo. They're claiming that there's no undue burden to them forcing doctors to get these hospital transfer agreements, again, very similar to admitting privileges laws. They're saying there's no burden because if the providers can't get the hospital transfer agreement, state officials will give the clinic a waiver. So there's no danger of the clinic ever closing as long as they continually apply for a license every 90 days. And so, I mean, this is a ridiculous thing to force a clinic to go through, especially because they can't be sure that at the end of that 90-day period, they're going to get this discretionary waiver. So to say that Casey is under siege right now would be putting it lightly. In addition to attacking cases, states have now decided to pretend to care about marginalized people. They're using marginalized people as weapons, as they always do, to prop up these so-called non-discrimination bans. These are really, really insidious bans, so I want to talk about them for a minute. States across the country have made it a felony for a physician to perform an abortion on a person if that physician knows that the reason for the abortion is related to a diagnosis of Down syndrome, or if the reason is because of the sex of the fetus or the race of the fetus, and yes, even the sexual orientation of the fetus. The Sixth Circuit Court of Appeals, just 2 weeks ago, I believe, let Tennessee's reason ban stand, for example. Now, setting aside the fact that people get abortions for myriad reasons and that there may not be one specific reason that a person chooses an abortion, I want to talk about how utterly preposterous these sorts of bans are. These states are calling them non-discrimination bans in order to appear as if they're truly concerned about the plight of babies of color and disabled babies. And the notion that states are concerned about discrimination against babies based on their sexual orientation is utterly absurd, because these same lawmakers and advocates are trying to strip LGBTQ people of their rights as we speak. And also, I don't know what a gay baby is. I don't know how that works. Conservative lawmakers across the country, many of whom are white and Christian evangelical, with all of the misogyny and racism and homophobia and transphobia that tends to come along with being white, conservative, Christian evangelical, they expect us to believe that they are really concerned about not enough girls being born, that they're really concerned that there are not enough Black babies being born, and that there are not enough gay babies, I guess, being born. And in order to jumpstart the birth rate of these populations, they want to ban doctors from performing abortions on pregnant people who choose abortion due to discrimination, right? They think pregnant people are getting these abortions based on discriminatory reasons, and these Christian evangelicals have had it. So they're pushing these bans under the guise of anti-discrimination, but everyone in this Zoom room knows that it's truly about exerting control over people's reproductive autonomy. It's about states forcing pregnant people to carry pregnancies to term, even if they don't want to. And now, even a modicum of common sense lays bare the sheer absurdity of some of these bans. My favorite is the race-selective ban. Lawmakers who feign concern about Black fetuses, but who do nothing to help Black children, Black adults, Black people generally, they're apparently concerned that Black women are choosing abortion once they find out that their baby will be Black. It's ridiculous when you say it out loud. I mean, if there is anyone in this Zoom call who has ever heard of a Black woman going to a doctor and saying, "Doc, give it to me straight. Is my baby gonna be Black?" Like, I wanna hear about it. Because if this has happened to you or to someone that you know, that's bonkers. And I feel like there needs to be, an expose, maybe a documentary of some sort about this, because it sounds utterly illogical to me. But logic is not the point. The point is to pile on regulation on top of regulation until providers simply give up and decide that it's not worth it to continue doing abortion care. And so that's why the RJ framework is so important, because as a clinician trying to provide care, as many of you are, or as a lawyer trying to defend these legal rights, or even as a journalist trying to cover these fights, like me and my work spouse, Jessica Mason Piclo, do, it can feel isolating. It really can, especially in a climate as anti-abortion as the one that we live in right now. But reproductive justice connects the fight for reproductive rights to the fight for other social justice causes. So really, we're just all fighting for human rights. And that's at the core of reproductive justice. And that's why it's so exciting that lawsuits are starting to use that framework. So the Sister Song Reproductive Collective, just, shout out to Sister Song, they've been leading the charge in this regard. They filed a lawsuit challenging Georgia's 6-week ban last year, and that lawsuit centered women of color in a way that I have never seen a complaint or a petition center women of color in an abortion rights lawsuit. They won an injunction in that case. Sister Song is also plaintiff in another case, a case filed in state court in North Carolina. That case challenges several abortion restrictions, and again, the lawsuit centers women of color. This is a new trend, and it's an exciting trend. It's going to force the courts to reckon with the framing of abortion as a human right, with the framing of abortion as a positive right. And also, it's going to set up Sonia Sotomayor to write some really kick-ass dissents. And I have to say, I'm really looking forward to that quite a bit. So our legal rights, they're being chipped away because legal rights are subject to change, right? Legal rights are subject to the whims of the Supreme Court, to the whims of the federal courts and the state courts. Human rights, on the other hand, are static. So when we talk about abortion as a human right, then to get back to Professor West's framing of negative rights versus positive rights, we're talking about it as a positive right. Negative rights, they permit inaction. Negative rights permit governments to leave you on your own. If you're pregnant, you're on your own. If you need an abortion, you're on your own. Positive rights, on the other hand, compel state action. They compel the government to help people. Declaring abortion to be a positive human right would require the eradication of the Hyde Amendment. It would require public funding for abortion. And you might be thinking, well, this country is never going to declare abortion to be a human right. Imani, you're crazy. Well, maybe not on the federal level, but certainly at the state level. Virginia did it. Y'all did it. When Governor Northam signed the Virginia Reproductive Health Protection Act, making Virginia a safe haven for abortion access in the South. That's a huge deal. Even the Kansas Supreme Court decreed abortion to be a human right in a beautiful, albeit lengthy opinion that discussed philosophy and John Locke. And if Kansas can do it, if Virginia can do it, then other states can do it as well. It's going to require organizing, to be sure, and it will require moving the abortion wars out of federal courtrooms and into state courtrooms, where in many cases, judges are elected by people. And so people actually have more control over the outcome of lawsuits if they elect the proper judges. And in some cases, it will require moving the conversation out of courtrooms entirely and into the marketplace of ideas. And when we do that, great things can happen. If we view abortion rights through a reproductive justice lens, then the right to raise healthy children and families or not becomes a human right. And a human right is one in which the government not only should, but must interfere to provide assistance. As Professor West put it, reproductive justice is a political and a moral project. The court-created abortion right is a judicial and a constitutional one. Courts are not concerned with the morality of abortion, or at least they shouldn't be. Courts are concerned about the power of the states to criminalize and to regulate abortion under the Constitution. The morality of abortion and whether or not abortion is a human right, that's a political discussion. And that's a discussion that we need to be having with our neighbors. That's a discussion that we need to be having with people who call themselves pro-life. Because the abortion wars have become so toxic that it has made people on opposite sides of the debate feel like there's no gap that can be bridged between the two positions. But there plainly are. For example, studies have shown that if you ask a person whether or not they think there should be public funding for abortion, they're probably going to say no. But they're going to say, I don't want my taxes to go to pay for abortion, that kind of thing, even though we know taxes don't go to pay for abortion. But if you ask that same person if they think it's fair that a poor person should be refused access to health care, to medicine that a person of means has access to, the answer might be different, because they might say, well, no, that doesn't seem fair. And then you can start having a conversation from that place and begin to talk about the morality of abortion, why it's necessary, what the history of it is, how it really didn't become this great horrible thing until guys decided they didn't want women mucking about in their medical business. They were all witches and midwives, and that just had to stop. So, you can start talking to people about what is necessary to reduce abortion rates without criminalizing it. And reproductive justice is the place to have that conversation. It's the place you can begin to have these difficult colloquies with people that you may not think you can reach. And that's why I remain optimistic despite the profound losses that the movement now is experiencing and has experienced, because reproductive justice is not dependent on court wins and losses, right? Reproductive justice goes beyond legal rights. And when we think beyond legal rights and begin to think about access, who abortion serves and who needs abortion care, that's when we're in the realm of RJ. When we're helping abortion funds, when we're finding places for people to stay, when we're helping them find money to help pay for the abortion, to help pay for lodging, to help pay for healthcare, that's where RJ lives. And that's why RJ is the way forward. That's why reproductive justice is the way to reproductive liberation, because it takes into consideration other issues of social justice that inform a person's right to access abortion, a person's right to make decisions about their body, issues like universal health care, job security, food security, police brutality. How can a Black mother raise a kid if that kid is going to be gunned down by a vigilante in Florida when he's getting an iced tea and some Skittles? How can a Black mother raise a kid if that kid is going to be shot in her bed by Kentucky cops? Reproductive justice connects all of these fights. How is a Black mother supposed to live in Flint, Michigan, where they haven't had good water in 4 years? These are the kinds of things that reproductive justice forces us to think about. And so it's definitely a difficult time for abortion rights. Like, I'm not going to sugarcoat it. And it's easy to get discouraged or to feel like you're not doing enough. So I just want to say to everyone in this Zoom room, especially to people who are working in this space, sometimes just existing is resisting. Sometimes just getting up in the morning is an act of resistance. And I think that's something that has helped me over the past 4 years. And I hope it's something that other people can take to heart, because this is truly a very difficult time for all of us. I mean, pandemic aside, we're in a fight that is not likely to be resolved soon. But since we're fighting for justice, I really do think it's a fight that we can win.